Hello friends, today we will discuss about an important topic, investigations. When we hear about word investigation, then first thing comes in our mind is what? That investigation is collecting of evidence by police officer. But it is not complete definitions. Complete definition given in CRPC, which is inclusive definitions. CRPC is section 2H uh, defines investigation is that all proceeding under this code for collecting evidence by police officers and or person other than police officer which is authorized by magistrate or court but not a magistrate is investigation. If we elaborate the definitions given in section 2 CRPC, then we can conclude that judicial officers or magistrate has no power to conduct investigations. Only the police officers has power to conduct investigation, and exception is other person other than police officer which should be authorized by judicial magistrate can conduct investigation. So not only a police officer but person other than police officer is also empowered to conduct investigation but should be authorized by court or magistrate. Before going into details of provision of investigation, first we should know about the difference between investigation, inquiry, or inquest and trial. Investigation, we have already discussed that police officer has power to conduct investigation. It is a proceeding, all proceeding under this code for collecting evidence. And inquest, inquest can be done by police and magistrate both, but investigation can only done by the police officers or a person other than the police officer, but should be authorized by judicial magistrate. But inquest is done by the police officer also and by the court also. Object of inquest is to ascertain the reason of death or injury or commission of crime. Third one is that what is inquiry? Inquiry can only done by the court, not the police. Police is not empowered to conduct an inquiry. Object of inquiry is to know or ascertain the facts, but other than the innocence or guilt of accused. Trial is that object of trial is to ascertain the innocence or guilt of the accused, and trial can only done by the judicial magistrate or court. Police officer is not empowered to conduct a trial. So that is the difference between inquiry, inquest, trial, and investigations. Then what is the purpose of investigation? Purpose of investigation is to proceed the place of offense. When police officer receive information regarding the commission of cognizable offense, then at first he proceed the place of offense. So that is the first purpose of investigation is that. Second one is that when the police officer proceed the place of offense, he try to know the settlement of facts and circumstances of the case. So that is the second purpose of investigation. Third is discovery and arrest the suspected offender. Police officer trying to know the settlement of facts, then he arrest the suspected offender and discover the object or facts of the case. Third one, third is that fourth one is that he take the statement of the person who know about the commission of offense. That is the witness. That statement should be that statement can be reduced into the writing as police officer thinks fit. And we also others purpose is that to discover the seizure and things of which the offense is committed, to prove the offense. So he also discovered the seizure or whatever the weapons, whatever the things which is used to commission of the offense. Last purpose of investigation is the formation of opinions. For what? For what? The collecting of materials that should be sufficient to file a charge sheet or not. So that is also a purpose of investigation. Now, how the investigation start? Investigation start after the receiving of informations by the police from any of the person or any of the source in respect of commission of cognizable offense. If police officer receive information in respect of non-cognizable offense, he cannot start investigation himself, but only with the direction of court. When police officer receive information, first information, so that information is known as f.i.r. Section 154 Cr.P.C mention about it that when police officer receive information, first information in respect of commission of cognizable offense, then he lodge an f.i.r. So that information is known as f.i.r. f.i.r is nowhere defined in Cr.P.C actually. Generally, the first information received in respect of cognizable offense, that is known as an f.i.r. under section 154 Cr.P.C. f.i.r. can be oral or written. It does not require that f.i.r. should be in written form. It can be, information can be given orally also to the police, and that can be lodged in an f.i.r. The ingredient of f.i.r. is it may be oral or written. Second ingredient of f.i.r. first information report, that is that information must be in respect of cognizable offense. If information is in respect of non-cognizable offense, it cannot be lodged in f.i.r. Third is the police officer has reason to suspect the commission of cognizable offense. If police officer has not reason to believe the suspect of commission of cognizable offense, he will not lodge an f.i.r. Reason to believe means the information should not be cryptic or vague or incomplete the identity of the offense. If police officer has not received complete identity of the offense or identity of the accused, who has committed the offense or what type of offense has been committed, then he will not get an f.i.r. He will proceed the place of offense and try to know the commission of cognizable offense, and where if he received the information regarding the commission of cognizable offense, that statement can be an f.i.r. For example, Supreme Court says that if police officer receives oral information or on telephone regarding the commission of cognizable offense which is credible and complete identity of the accused but not lodge an f.i.r., or in spite of lodging an f.i.r., he proceed the place of offense and take the statement of the persons regarding the commission of cognizable offense and lodge an f.i.r. The Supreme Court said that earlier statement was an f.i.r., not the subsequent statement after the proceed of the place of offense is an f.i.r. Because of that, the information was credible and complete the identity of the person who has committed the offense, then that statement should be an f.i.r. So that is the definition of f.i.r. or ingredient of an f.i.r. What is the jurisdiction of police to lodge an f.i.r. if offense has been committed at another place and information of regarding the commission of that offense given to the police station of another place? Can that police in charge of police station can lodge an f.i.r.? Yes. he can lodge an FIR. He cannot deny to lodge an FIR on the basis of territorial jurisdiction. He cannot say that he has no jurisdiction to conduct an investigation, so he will not lodge an FIR. The Supreme Court very well said that in the judgment of CHHABRA that police officer cannot deny to lodge an FIR on the basis of territorial jurisdictions. So now the FIR is that police officer cannot deny to lodge an FIR on the basis of territorial jurisdiction. Sorry. Now, what is the evidentiary value of an FIR and 161 statement? What is the procedure of investigation after the lodging of an FIR? Police officer proceed the place of offence. He will record the statement, which should be reduced in writing also, but he cannot force the person who has recorded the statement under 161 to sign on the statement. And that is also a statement given under 161 is not admissible at all in evidence. But under Section 27 Evidence Act, Indian Evidence Act, if some facts or some things have been discovered on the basis of the statement given by the accused, that is admissible. So Section 25 and Section 26, the Section 27 is exception of Section 25 and Section 26 of Indian Evidence Act. Because of that, Section 25 says that any information given to the police or any statement given to the police during the course of investigation, that is not admissible in evidence, because that statement can be possibility to use by misusing or by forcing the witness by the police, because the police officer has power to call that person and record the statement into the writing. A police officer can force him to put signature on the statement. So the Indian Evidence Act provides the admissibility of the statement given under 161. But under Section 27 Indian Evidence Act, the Police Act says that if some facts has been discovered or something has been discovered from the information given by the accused to the police, that part is admissible in evidence. If we think about the evidentiary value of FIR and 161 statement given to the police, then FIR can be used for corroboration and contradiction. But 161, a statement given to the police is only used to contradict the witness or contradict the witness who has given the statement. And corroboration is what FIR can be used for corroboration of informant only who has lodged an FIR, not the other person. FIR cannot be corroborated for the statement given by the other person who had not lodged an FIR. So Supreme Court clearly says that FIR can be corroborated for the statement only given by the informant who has lodged an FIR, and purpose of use for purpose of contradiction also for the informant who has lodged an FIR, not the other persons. So that is different between the evidence value of FIR and 161 statement. Thank you. Next time we will come with another important topic and we will discuss about it. Thank you.